He, that is now Dr. Dintwe, alleges that during my tenure as Director General of the Free State Security Agency, I lacked the requisite understanding of the powers of my office vis-a-vis that of the Office of the Inspector General of Intelligence. 46.2, he alleges further that I exhibited a contemptuous and recalcitrant attitude towards the OIGI and that I undermined its work. 46.3, he further alleges that I assisted the then Minister of State Security, Mr. Bongani Bongo, to reduce the powers of the Inspector General of Intelligence and to remove him from office. 46.4, lastly, he alleges that the manner in which I dealt with vetting was contrary to the provisions of the requisite legal instruments and legislative framework. In paragraph 47, he then says, I hereby apply to cross-examine him on the above stated aspects and to put to him the version contained in AF1. To the extent that Dintwe ventures into the legislative framework and alleges that I misunderstood my powers, my version may be summarized as follows. The legislation states that the Director General of the SSA is empowered in law to issue the secret clearance of the Inspector General of Intelligence, IGI. Consequently, the Director General is also empowered to withdraw the secret clearance of the IGI. 47.2, the IGI is required to comply with all security requirements applicable to all the employees of the SSA. In fact, the IGI previously abandoned the litigation in which he attempted to make similar inaccurate and spurious allegations. There is no reference, that is 47.3, in Dintwe's claim to any fact supporting his claim that I abused my powers in any way whatsoever. Instead, it reveals in his allegations his own misconception of the applicable legislation. I'm satisfied that the applicant did not comply with the requirements of the rule in the way in which I have indicated. The applicant needed to have identified exactly what parts of the affidavits of the witnesses he implicated him and which ones he disputed and which ones he did not dispute. And he needed to have given a full version of his side of the story in regard to all the allegations. I indicated earlier on that I have made rulings before in relation to applications for leave to cross-examine, in which I've indicated that the rules require that an applicant for leave to cross-examine a witness is required to furnish the commission with his full version or account of the events that he is implicated in. In this case, one, the applicant has not complied with the rule in relation to identifying in the affidavits of the witnesses exactly the paragraphs and parts of paragraphs that he disputes and which implicate him and what his version is in regard to that. But two, he has, on his own admission, said that his version is incomplete without the documents that he sought to obtain from the State Security Agency. In those circumstances, I can see no reason why it can be said that it is in the interest of the work of the commission to grant the applicant leave to cross-examine any of these witnesses in the circumstances that I have set out in relation to non-compliance with the rules of the commission and in relation to there being no explanation as to why, having said that he his statement would not be complete without the documents that he asked for from the State Security Agency, and the Commission having given him time to ensure that he secured such documents, and the State Security Agents having undertaken to give him such documents, why he has not pursued that and why he is no longer seeking to place those before the Commission so that his statement before the Commission is complete. In all of these circumstances, I've concluded that the applicant's application stands to be dismissed, and it is so dismissed.